Let's go ahead and go then to item number 6, state and local agency access to customer information.
Okay, that is mine. But before, if you all indulge me, before I start that item, I noted in the annual report that we do every year has a staff listing that includes commissioners, and it always includes the end date of their terms, which we learn from the oath of office. So I took a look at the annual report, and it shows that we have 3 commissioners whose terms are ending on October 1st of this year. One is the chair. You were correct about that. And then Commissioners Cubas and Rubin, your terms are set to expire on October 1st. So if you want to be reappointed, you should be talking to the governor's appointment staff. And you can, if you could, let me know too what your intentions are, because it's helpful for us to know whether to expect to have vacancies while the governor's office fills them, if there are going to be any. So the 3 with the expiring term, the terms that expire this year are Commissioners O'Brien, Cubas, and Rubin. The rest of you have until 2023.
To the extent that I can be helpful to Anna and Richard regarding how to reapply, I'll just reach out to me. I'm not entirely sure for this office, but just reach out.
Okay, and so with that out of the way, I will begin memorandum of 2021-38, which has to do with notice of an administrative subpoena. The general purpose of this topic is to look at whether the law should require that an administrative subpoena, which is an investigative subpoena issued by a state administrative agency. It's not a subpoena used by litigants in litigation. And, you know, because it's investigative, it will often precede any litigation. The question is whether, when those subpoenas are used to obtain customer information from a communication service provider, whether there ought to be notice given to the customer as well as the subpoena being served on the service provider. This is one of the threads that remains to be tied off coming out of our general study of government access to electronic communications information. And we have been moving towards a proposed law that would require that notice be given to customers. And as has been discussed in prior memoranda, there's constitutional argument for that. There's also other examples in California law. One of those is the California Right to Financial Privacy Act that regulates government access to bank records. And the other is the statute that the chair mentioned before the break, which is Code of Civil Procedures section 1985.3, which requires notice to a consumer when a subpoena is used to obtain the consumer's information from certain specified kinds of businesses. And that is an example of the same kind of concern that we're looking at. It's not quite squarely applicable to this context because that's a subpoena used in civil litigation. And it's not exactly the same instrument that we're looking at, which is the administrative subpoena used in an administrative enforcement of administrative law. So back a couple of meeting cycles ago, when we looked at memorandum 2020-55 in the same study, that memo said, although this memorandum is not focused on the use of a subpoena for pretrial discovery, it is also worth noting the treatment of such a subpoena under California Civil Procedure section 1985.3. Under that section, when a subpoena is served on specified entities, which include medical providers, financial institutions, telephone companies, and schools, To obtain a consumer's personal records, a copy of the subpoena must be served on the consumer. This is another example of how existing law protects privacy by ensuring that a person whose records are sought from a third party has actual notice and an opportunity for judicial review prior to the records being produced. So very salient point, and something that we will definitely talk about in our report, but not an answer to the narrower question that we're studying right now. So in terms of this memo, at the last meeting where we discussed this, I presented a number of policy recommendations for what a proposed law should achieve on this topic. And the commission approved the staff going forward with the preparation of a draft to effectuate those issues. There was one exception that the commission wanted me to dig in a little further on, which had to do with evidence preservation. The staff had pointed out that under the Federal Stored Communications Act, there is this provision 18 U.S.C. 2703F, which enables the government to issue communication service providers a preservation order, which requires them to make a copy of the customer's electronic communication records and hold that copy pending some further legal process that would require it to be disclosed to the government. And as we discussed, the purpose of it is to prevent spoliation of evidence, that if you're trying to get the email or whatever of the person who you're interested in and investigating, you don't want them to have an opportunity to modify or delete their records before you actually have access to them. So this lets you sort of freeze things in place pending the eventual issuance of a warrant or subpoena to obtain the information that you've asked them to freeze. And when we talked about that, the commissioners asked me to look further at, how does this operate under federal law? Has it caused any problems? And in particular, how does it work for communication service providers who part of the service they provide is the ephemeral nature of the communication? They promise in their terms of service, your communication will be deleted on some specified schedule. And so you can use it to communicate in a way that will not result in there being a permanent record of the communication. And that's the feature of the service. So the commission asked me to take a look at that. So what this memo does is that it presents an initial draft of statutory language to effectuate the decisions at the last meeting. And then it includes some discussion on the last point, which is whether and how we would implement an evidence preservation rule in this provision if the commission decides it wants to do that. I think for convenience, what I'm going to do is I'm going to walk through, and if we'll talk about the different sub issues, but I won't ask for a vote on them until we get to the end and we've sort of got a sense of where the commission comes down on all the details of the proposal. And then you can vote on whichever bundle of those elements you are approving. So the draft is attached as proposed Government Code Section 11181.5. And that number relates to the first point that I explained in the memo, which is that the location of the provision. I thought there was a lot of substantive sense in putting it adjacent to existing Section 111A1, which is the provision that authorizes and regulates the issuance of administrative subpoenas by state agencies. This would be a sort of a supplemental rule governing those subpoenas, and so I thought it made sense for them to be next to each other in the code. Unfortunately, that part of the code's pretty densely packed, and there's no room for it, so I made it a decimal extension code section, which is less than ideal, but not terrible. I thought on balance, it made more sense to deal with the more complicated section number than try to put it somewhere else and include cross references. So that's the first point, and I assume nobody has any concerns about that. All right. The other thing I've done is I've included a set of definitions that I thought would be helpful, turned out to be helpful in drafting the rule. It made the rule much more intelligible to have some definitions of concepts. So the other thing I wanted to mention about that is that I pulled those definitions from the existing California Electronic Communications Privacy Act, CAL-ECPA, which is sort of the main statute in the penal code addressing issues of government searches of electronic communications. And I saw some utility in having parallel definitions between that law and this law, because they're really addressing the same kinds of issues, and to the extent that there's judicial construction of the terms, it'd be helpful to have this kind of parallelism. So that's, again, that's just explanation. That's not substance, so I'm not expecting any concerns. If you have them, share them. Otherwise, I'll move on. Okay, timing. This is the first actual substantive issue. Many of the provisions of the draft are drawn from the California Right to Financial Privacy Act, again, on the theory that it's helpful to have parallelism between statutes that are doing essentially the same thing. And when I was looking at the source provision, Government Code Section 7474, A3, one of the elements of that existing rule is that when you serve an administrative subpoena to obtain financial records, a customer's financial records from a financial institution, you don't get to actually obtain those records for 10 days. And that makes sense because it gives the customer, and I think this is the reason for the delay, it gives the customer an opportunity to object and petition the court to quash the subpoena. There is this drafting imperfection, I think, in that the statute doesn't say 10 days from what. It doesn't specify the trigger of the 10-day period. It just says you can't do it for 10 days. It requires that you serve a copy of the subpoena on the customer, which we're doing too, but it doesn't say whether, it doesn't expressly require that the service of the subpoena on the bank and the notice to the customer be contemporaneous. They don't have to be by statute on the same day. And then they say, well, and you can't get the records for 10 days, but they don't say whether that's 10 days from the subpoena or 10 days from the notice to the customer. And I think that's a problem because I think in terms of the policy, the idea is that it should be 10 days from the customer obtaining the notice because, as I said, I believe the purpose of this is to give the customer a meaningful opportunity to respond and have that 10-day period to put their ducks in a row and get to the court and move to quash. So I think that in our proposal, we ought to clarify that it's 10 days from the date of service of notice on the customer. Now that sort of introduces some other questions about timing because there are different ways that you could do that and the memo walks through them. One of them is you could specify that the notice to the customer has to be contemporaneous with the service of the subpoena on the service provider. I actually see a potential problem with that, and that has to do with spoliation of evidence. If we're going to include a rule that says that the agency can require the service provider to make a duplicate of the information to prevent it being modified or destroyed by the subject of the request, it's going to take a little bit of time to put into place. And if you give the notice simultaneously to the service provider and the customer, it seems like there might be an opportunity for the customer to act very quickly and modify the record before the service provider could put the freeze on. And so I think as a practical matter that it might make sense for you to stagger them, to give the notice to the service provider first, and then wait a couple of days and notify the customer. So that would be inconsistent with the idea of requiring contemporaneous notice. And what I suggest as an alternative is that if you want to leave the agency that flexibility, that you require when they serve the notice on the customer that they also serve a proof of service on the service provider that says the date that the notice was served on the customer, and the 10 days runs from that date. So as a service provider, I get served with a subpoena and I think, okay, I'm gonna have to do something here. But I don't have to do anything yet until I have been served with notice that the customer has also been notified. And then 10 days after that date runs, if there's no motion to quash, then I produce the records. So that's my suggestion. It's not fully effectuated in the draft language because I'm just proposing it. But my suggestion is that we require the 10 days be tagged onto the data service to the customer, and that the agency be required to serve the company with a proof of service that notifies them of the date of service on the customer. Does anyone see any problems with that?
Yeah.
Yes, Commissioner Creel.
I'm generally in favor of your approach. Number two, option number 2 on page 3. I did have a question though. It occurred to me, what happens in the scenario if the service provider just decides to voluntarily turn the stuff over? Is that possible? Is there anything that prevents them from doing that? So, so let's say they get the notice and the consumer has been properly served and all that, but the provider just decides to voluntarily turn the stuff over without waiting to see if anybody moves to quash or anything like that.
It happens in real life.
I will have to check, but I believe that CalECPA includes a general provision that bars disclosure of customer records to the government absent compulsory process.
Okay. If that's the case, then if that contingency is covered, then we're good.
Well, that's kind of right now. Would it be? And me, my is who obligation to serve the customer. So now you're shifting a responsibility on the service provider to serve the. Can you guys hear me? Because I'm getting.
You would break it up a little bit, but no, that's not my proposal. My proposal is that the government retain the duty to serve the notice to the customer and serve the proof of service to the communication provider.
But Brian, like when you're practicing, that's almost impossible to do it contemporaneously.
Yeah,
because
yeah, that's why I'm not proposing that it be required to be contemporaneous, that there can be a little bit of slack, but the 10 days don't run until the customer gets served. Everyone
yeah,
okay with that?
and I like to borrow from 1985 the requirement of proof, because that, we have a garnishment statute. You have to have it for IRS holds and garnishments also, or liens. You have to have notice that the consumer has been served. Otherwise, as a service provider or as a witness or whatever, whoever you may be. In my case, it was like payroll. I was general counsel for a payroll provider, a payroll processor. So we needed to have proof that the employee had actually had, notice. Anyway.
Yeah, I actually, during the break, I was looking in 1985.3, and there is subdivision C says, prior to the production of records, the subpoenaing party shall do either the following: 1, serve or cause to be served upon the witness a proof of personal service for compliance with subdivision B, which is the obligation to provide notice to the customer, I believe. So yeah, I think
administrative agencies follow it too, and they may not be in litigation. They may just be doing regulatory audits, compliance audits. Everybody kind of looks to that consumer notice. So just like how we did with some of the probate stuff, I think we should kind of mirror what's happening in the CCP.
Yeah, definitely. I will look to 1985.3 as a possible model for the proof of service language. And Commissioner Carrillo, I believe I'm correct that there's a general prohibition on disclosure in the CalECPA, but if I'm not, I will address that language in that issue in the next memo.
Yeah, I saw that on the back page of the memo, there's the 3 conditions for the provider to actually turn over the stuff, throwing in a reference to that provision in CalECPA in those 3, maybe make it 4 conditions, or at least, include a reference to that might be useful. Because I could see a provider just obviating this whole process and just turning this stuff over.
Yeah. I don't think that's permitted, but like I said, if I'm mistaken, we can bolster our statute. And
I can tell you, it depends on whoever the clerk is. Courts do it. It's whoever's reading it and receiving it.
Yeah, I expect high variation in procedural compliance here.
Although, if there is a prohibition on disclosure, there's probably also a prohibition in the terms of service. So that they might have a self-interested reason to be meticulous about it.
They might, but I could also see it going the other way. I mean, you quoted from Snapchat's terms of service, and I think we could be looking at high variation among the service providers. Some of them might want to be helpful, so that to cover themselves, they could go either way. We require a subpoena before we turn anything over, or we'll turn anything over regardless. Like, that's our right.
Yeah, actually, now that I think about it, I think there's also a governing prohibition in the Federal Stored Communications Act that prohibits disclosure. One of the cases I was looking at in preparing this memo, that was really a central issue, because the service provider, Google, had itself discovered evidence that its customers were involved in child pornography and other child sexual exploitation and reported it. But the Stored Communications Act includes an express exception for disclosure of such matters. And so the defendant was challenging the resulting search on the grounds that Google had been acting as a government agent and had seized and searched their records as a government agent, implicating the Fourth Amendment. And part of the reason that wasn't the case is because it was expressly carved out that was permissible. So I'll look at the SCA also, and it might be worth pointing out, if nothing else, pointing out in the comment and in the narrative part of the recommendation that there should be no voluntary workarounds. I think it's a good point. Okay, so another point that I included that I expect is going to be uncontroversial is that the state Right to Financial Privacy Act includes a record keeping component. If a bank is served with a subpoena for customer records, they have to hang on to the subpoena and the related information about that search for 5 years and make that information available to the affected customer on request. And I've incorporated equivalent language in here. So presumably you know about it, because under our proposal, you're going to get the subpoena, but it seems to make sense that, if for nothing else, to sort of police compliance by communication service providers, that they have a record of requests and their reaction to them. Okay, so now on to the main substantive question, which is this issue about record preservation. So the way it works under the Federal Stored Communications Act is that the government submits this request, preservation request, to the service provider, and the law mandates that the service provider retain a copy of the information for some specified period, I think. They don't turn it over to the government, they keep it themselves. And it's only provided to the government if the government then later comes back and provides compulsory service, lawful process, like a subpoena where a subpoena is appropriate, a warrant where a warrant's appropriate. So it doesn't actually result in disclosure, it just results in duplication, and the duplicate being held by the service provider pending order that they turn it over. So one of the things I discovered, actually, Alex discovered this for me, Alex Azad, because I asked her to take a look for this kind of thing. There is a professor, Oren Kerr, who's kind of famous in the realm of privacy of communication, computer information and communications. And he wrote basically an op-ed in 2016 in which he offered sort of the untested proposition that preservation orders might be unconstitutional as a government seizure, not as a search because the information is not disclosed, but that if the communications service provider is compelled to do it, then they're acting as a government agent. And I think there's an argument there. And he said, for Fourth Amendment purposes, taking a copy of somebody's private information and storing it is a seizure governed by the Fourth Amendment. And therefore you would have to have probable cause before you could do that. And he suggested somebody ought to make that argument and see what happens. And so later, in 2019, there was a case in which that argument was made in the Ninth Circuit, US versus Basie. And the ACLU was an amicus in that case, and they raised the argument that Professor Kerr had suggested, that preservation orders are an unconstitutional seizure under the Fourth Amendment by a government agent. And the case didn't wind up turning on that issue, wasn't decided, and I believe it was also an unpublished case. And I found another unpublished California federal case raising the same argument, both of them involving child pornography, which I think must be a lot of these cases. And in that case, which was also unpublished, the court in dicta was dismissive of the argument. And I think the problem that I have with the argument is that the courts have held that for the purposes of the Fourth Amendment, a seizure of property occurs when there is a meaningful interference with the individual's possessory interest in the property. And so the question is, does making a copy of someone's files and preventing them from modifying or destroying that copy, is that a meaningful interference with their possessory interest in the property? The person can still modify or delete the records, their own copy of them. They can use them for any purpose that they could before. The only thing that they're not allowed to do as a result is spoil evidence, right? They can't destroy or modify the copy that will eventually go to the government if the government subsequently produces lawful process sufficient to obtain the information. So their use of the record for the information for their own purposes in every other respect is unaffected. The only effect is that they can't modify or delete records that will perhaps eventually go to the government pursuant to a lawful search. And it strikes me as, I'm skeptical that that is a form of privacy that the Constitution protects. Maybe, but so far it's been presented to two courts who have not accepted the argument. Neither one a precedential decision. And maybe eventually the argument will be made and accepted by a court, but I'm a little skeptical.
I'm more than a little skeptical. I mean, after all, there are privacy rights involving the attorney-client privilege, and there's the crime fraud exception to the attorney-client privilege. So, obviously, if we're worried about preserving records, we're trying to prevent crime fraud. I know the statutes are written in that way, but that's how I see that issue.
Yeah, and the ACLU made a further argument in their brief, which has a slightly different angle of attack on the problem that I'm also not sure that I embrace, which is they pointed out, there are these requirements that the government publicly disclose their use of the preservation order mechanism. And so we have empirical data about how often it happens. And so they pointed out that it happens a lot. The government's use of 2703F is pretty frequent. And the law requires them to reimburse the service providers for the cost. So there's sort of a limiting principle on how much they're going to do it. They're not going to do it if it's pointless. But ACLU pointed out that it's only a small minority of cases where a preservation order actually leads to a warrant or subpoena that results in the disclosure of the records. So most of the time they do it sort of as a preventative measure, but then ultimately decide not to proceed with the search. Now, personally, I don't see the harm from that, but their argument seems to be that when you do that on a massive scale, that there's some sort of aggregate effect that is concerning from a privacy point of view, that the government is out there sweeping widely people's personal information without probable cause. And in fact, they never, in many cases, they never eventually even proceed to legal process to compel disclosure, which means they probably thought at the end of the day, we don't have a case here. Let's just walk away from this. And so it sort of seems like they think that that's in the aggregate, some sort of police state maneuver, that there's these massive dragnets of your information. I don't quite see it, because if the information never winds up being provided to the government and the copy is eventually destroyed, which it would be, there hasn't really been any kind of effect on the customer at all. And so I don't quite see it, but that's their argument. And again, maybe a court would embrace it. I see a hand, Commissioner Simpson.
Well, I was just curious, is on the preservation orders that the ACLU was talking about, is there a time duration that the preservation order, you have to preserve it for at least a month?
Yeah, I don't recall the rule, but I believe that that's correct.
Okay.
Yeah, they time out.
It's not perpetual. Okay.
And they're not prospective. That's the other thing.
Yeah.
They're a snapshot. So it's
Right.
not like you can create a preservation order that's going to continue to pull in future records. That's not permitted.
Okay.
Commissioner King?
Yeah, I don't understand the ACLU's approach, because if you look in the civil context, I understand their point about the criminal context, that a lot of preservation orders aren't acted upon and the records are never disclosed. But in the civil context, there are literally tens of millions of litigation holds underway in this nation right this second. And the litigation holds often, involve corporations and employers, but I represent a public entity, and public entities are subject to, I probably have over 100 litigation holds involving the public records of the public entity I'm involved in. And that's not quite as formal as a preservation order, but it's the same sort of concept.
Yeah.
And so, in the civil context, a lot of those litigation codes do result in the disclosure of records, because that's just part of normal civil discovery. So I think this is a non-issue. It's cute. I looked up that professor who you said has been making these Fourth Amendment issues. He seems to be part of this sort of libertarian, Cato Institute, Reason Magazine sort of perspective. And
He is a Berkeley guy.
okay, well, yeah, they're nice intellectual puzzles, but as a practical matter, I don't give much worry about them.
Yeah, although one of the reasons I wanted to explore it pretty thoroughly is that, eventually, if we follow this thread through to a final recommendation, it's also going to be a bill. And ACLU is an active advocate in the legislative process, and they're quite well respected and taken seriously. And so I would expect that if we were to simply reject the argument, we would hear it again. And we would hear it again in a venue where it's harder to take the time to tease it apart as carefully as we're able to here. Often, you know, the accelerated schedule of the legislature makes it hard to get nuance on issues, and you'll just wind up being told, you know, you need to fix this. And you may argue back, and then the answer is still, nope, you need to fix it. And so I would rather go in with a proposal that doesn't have that poison pill waiting to pop once we have a bill. And that's partly why I proposed what I did in the memo, which I think is a way around that issue, which is on page 7, I proposed subdivision G, which says, when an administrative subpoena is served on a service provider pursuant to this section, the service provider shall promptly make a copy of any electronic communication information that is within the scope of the subpoena and within the possession of the service provider at the time the subpoena was served. Copy shall only be preserved until it is disclosed pursuant to the subpoena or the subpoena is quashed. So the key thing there is that this is the preservation requirement is embedded in a subpoena rather than a separate document. So you would not have this case that they're concerned about where there's profligate use of this easy preservation mechanism that never winds up coming to fruition. You would only require preservation where you're actually serving a subpoena that is going to lead to either compliance or quash subpoena. Commissioner Creo.
Yeah, I think I'm generally okay with your proposed subdivision G on page 7. I think Victor's generally right. Like, this is a fairly common procedure in other areas of the law. Anybody who's done civil litigation has done something like this. You know, this at the risk of presenting yet another superfluous legal academic view, to me this issue seems to exist at the intersection of individual privacy and also the concept that the law is entitled to every man's evidence, every person or every entity's evidence. So there's basically no right to hide or destroy or conceal relevant evidence in an official proceeding. So to me, G balances those competing imperatives.
Yeah, and that's what I was trying to do, was thread the needle.
Yeah, and I think this accomplishes that.
And this would operate in tandem with the thing we already talked about, which is that you wouldn't disclose the information until 10 days after the customer gets served, but you wouldn't have to serve the customer at the same time you serve the service provider. So in practice, my sense is the way it would work is I'm the Department of Real Estate. I serve this communication service provider for a licensee's emails related to an investigation that I'm doing. And I say, within that subpoena, I say, make a copy, preserve the evidence. Then 5 days later, I serve the licensee with notice, by the way, I've subpoenaed your email from your service provider, and I give the proof of service to the service provider with the date that the customer was served. Service providers already made their copy. It can't be tampered with. They wait for the 10 days to run, and then either they're going to produce or there's going to be a motion to quash. So I think that's how the timeline would play out, that there would actually be this staggering of these steps to make sure that the record preservation order has a meaningful effect. Does that make sense? That's Commissioner Simpson.
A quick question. Does the notice to the consumer include a notification that there's been a preservation order?
It could. It could. I mean, it would be in the subpoena itself. It would be a standard part of the subpoena. But you certainly that we could flesh out what the notice to the consumer contains, and it could include advice that a copy of your records were made.
The judicial council form will, that 1985 has, says that you have to preserve it. And generally for businesses, like in a law firm, they might send an email, if you've worked on these cases, don't destroy anything. And then it's so broad, it's drafted so broadly that you wouldn't have a clue if they're looking for porno, pictures, or what. You wouldn't know. And then generally records aren't gathered until we know that it's actually going to go, so that, and there's enough time with the consumer notice. So there's 20 days and then 10 days to act. So if they haven't taken any steps to quash the motion or the subpoena before you get to the 10 days, then, you know, it's not any burden. It's not any actual, it shouldn't be any business expense to preserve records other than a general inquiry.
Okay, so I believe that that's all the content that I presented. So what I'd like to do is go through and recap what we've talked about, and then someone can frame a motion. So this memo presents this draft language, which the staff, the next step would be to develop it into a tentative recommendation. In doing so, we would use the language that was presented, including subdivision G on preservation. Language would be added to require the proof of service be served on the communication service provider at the same time that the consumer is served. I will look at the possibility of specifying in the notice to the consumer, providing some information, like maybe a form notice with some information about what the consequence is, and including the fact that record preservation was ordered by the subpoena. And I will check to make sure that CalECPA or the Stored Communications Act has an effective general ban on voluntary disclosure while awaiting process. And if that is the case, as I believe it is, then I'll probably add some language to the comment and maybe the narrative in the tentative recommendation reflecting that. And I think that's everything we covered. So if everyone's comfortable with that as the basis for the tentative recommendation, then I need a motion, a second, and then I'll call the roll.
So moved.
I'll second.
Okay, thank you. All right.
Brian, you should take a roll call. vote.
Yes. Carrillo,
Aye.
Cubas,
Yes.
King,
Aye.
McAllister,
Aye.
Miller O'Brien,
Aye.
Rubin,
Yes.
Simpson.
Aye.
Okay, that's it. That's that memo. We're done. Thank you very much.
Okay, let's move to the next item. Then. Steve, are you ready?
All set.
Okay.
Hello, everyone.
And then we have guests too. So Angela, or we have Ms. Donlin.
Right. Thank you. So we have 3 memos here relating to Fish and Game. There's Memorandum 2139 and its supplement, which are public comment memos. And then we have Memorandum 21-40, which is a cumulative draft that consolidates prior decisions made by the Commission on previously presented public comment memos. I will start with Memorandum 2139. Once again, as with each of the public comment memos that we've been presenting in this phase of the study, the memo presents several categories of proposed revisions to the Fish and Game Code based on, the categories are based on the nature of the public comments we've received on the revisions. And each category is presented as a single consent item for decision by the Commission after an opportunity for questions or objections are made available. Before I briefly run through the various categories in this first memo, I need to correct and apologize for 2 typographical errors in the memo that were pointed out to us by and with thanks to the Department of Fish and Wildlife. On page 10, of the memo, there is a proposed revision to section 8037 that appears in the middle of the page, and there is a strikeout of the subdivision A designation in the first line that shouldn't be there. And then on page 14, there is under the heading proposed section 22-800. As you can see, the text indicates that this would restate a part of existing section 7710. However, the bold recommendation of the staff at the bottom refers to section 7720 rather than 7710. It should be 7710 throughout. Okay, so back to category 1 revisions, which start on page 2. These are revisions that are categorized as changes that should be made. Again, I'm not going to discuss any of the proposed revisions individually, but we'll ask for any questions on or objections to any of the proposed revisions in this category of revisions. Seeing none. Normally, I would ask for a roll call vote right now, but unless anyone has any objection, because of the nature of the memo, I think that I can present the whole memo and then just ask for a roll call vote at the end about whether the commissioners approve all the staff recommendations. Okay, so we will proceed along. Next category on page 11 is revisions that the staff has recommended should not be made. Any questions or objections relating to any of these proposed revisions? Okay, still seeing nothing. Commissioner Rubin, I'm having a hard time seeing you, but okay, there we go. Thank you.
I have not left.
That's fine, no problem. Thank you very much.
Fully engaged.
Okay, thank you.
You could only see the top of your head, Rich. That's what's going on.
Sorry
Right.
about that.
Okay, so now the next two categories are proposed revisions beginning on page 14. The first is changes that should presumptively be made. And then on page 16, further input required. I grouped these together because for reasons indicated in the memo, they don't even require a decision from the commission because they contemplate doing something further before we come back to you. But does anybody have any questions on or objections to any of the items in these categories? Okay. Then we have, let's see, on page 20, category 5 is a category of provisions in which no further action is recommended for the reasons indicated. Any questions on or objections relating to these revisions? Seeing none. And then the last category on page 21 is just informational material for the commission. No decision needed on that at all, but does anybody have any question about any of those? Okay, so now a roll call vote. I would appreciate a vote asking whether the commission approves all the staff recommendations in memorandum 2021-39 with the 2 typographical corrections noted.
I'll make that motion.
Second.
Great, thank you.
You know what? I just wanted just to check in with Ms. Donlin. Are you there? Did you have any questions? Okay. Oh, she is there. Okay.
Uh-oh.
The audio is off. Oh, I think she said no questions though.
Okay.
Did you say that, Angela? Okay.
We Ms. Donlin and I we have an ongoing process where we're communicating, informally, and
Good.
if there is anything that doesn't get said because of technical difficulties, we'll be able to bring it back to you.
No, that's good. I'm glad to hear you guys are working with each other. That's good.
Yes.
Okay.
Okay, so I will call the roll. Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner King,
Aye.
Commissioner McAllister.
Aye, sorry.
No problem. Thank you. Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
and Commissioner Simpson.
Aye.
Excellent. Thank you. Okay, next we have the first supplement to that memorandum. Follows the same pattern. Again, first category proposed revisions are changes that should be made that begins on page 2. However, before discussing this category, I need to make one more correction and then would also like to move one of the proposed revisions from this category to another category. So the correction is on page 2. I need to get to it to, excuse me. The heading is proposed section 24,800. This proposed section in the TR would have revised the existing section 15,700. And as was indicated in the TR and also was indicated in the blurb right below the heading, what it would have done was revise an obsolete reference to the State Department of Health Services. And it should instead refer to the State Department of Public Health. But somehow in the body of the section, I messed this up. So where there is a revision and a strikeout where it says State Department of Health Services followed by an underlined Department of Health Services, the underlining should be State Department of Public Health. And there is one other matter in here where I would like to, I guess with permission, move an item in here, which is on page 7. Everybody can get to that. Near the bottom of the page, under the heading Proposed Sections 29370, 31800. Both of these proposed sections in the TR would have revised the same existing section, 4304. And we got multiple comments on this, and some of the comments were supportive of what we had proposed, but there's other that we need to talk about. And so this section 4304 also appears later in this memo in the further input required category. After looking at this again yesterday, I think it would be easier for us to just put the whole section 4304 in the further input required category, so we can discuss all the proposed revisions at the same time rather than break them out. I don't think that they cleanly break out the way I thought they might. And so I'd like to take this out of category 1 and this will go in category 4.
That needs a motion. I'll make it.
Okay, well, I'll sure. I don't think we need, thank you. I appreciate that. I can just ask. I don't think that's requiring a vote, but does anybody have any concern about doing that?
No.
Okay.
You
All
can
right,
just,
thank you.
you can just incorporate it in the eventual motion on the memo as a whole.
Yes, that sounds fine. Okay, thank you. So returning again to category 1, which is again changes that should be made. Any questions about or objections to any of the revisions in this category? Okay, seeing none. Page 10 is the category of changes that should not be made. I'll make sure I have my stuff going right. Questions about or objections to, I think there's only one proposed revision in this category. Seeing none. Next category, now we're on page 11, changes that should presumptively be made. Any questions, objections? Next category is on page 12, further input required. Questions or objections? Seeing none. We move all the way to page 18, no further action recommended. Questions, objections? Seeing none. And then again, the last category is just informational, purely informational matters. Any questions about this one? Okay. So I would like or ask for a roll call vote asking whether the commission approves all the staff recommendations in this first supplement to memorandum 2139 with the correction of typographical error and the moving of that one revision from category 1 to category 4, as indicated before.
Once again, I'll make the motion that we do that.
Thank you.
Second.
Wonderful. Thank you. Okay, Commissioner Carrillo,
Aye.
Commissioner Kubas,
Yes.
Commissioner King,
Aye.
Commissioner McAllister,
Aye.
Commissioner Miller O'Brien,
Aye.
Commissioner Rubin,
Aye.
Commissioner Simpson.
Aye.
Excellent. Thank you. And the last memo is also an informational memo. This is a cumulative draft, which just, as I said, it combines your prior decisions and starts putting things into, it puts the ones which are approved to go into the cumulative draft in a cumulative draft in appropriate legislative form. And then it has a table also, which is attached to it, which sort of allows you to keep track of where we are on the other revisions that we're still working on with the commenting entities.
It's very nice too, Steve. Looks good.
Okay, any questions or comments about this memo? Okay, and once again, I guess it's Ms. Donlin, if she's still present. I can't see the visitors, but
She is, but she hasn't raised her hand.
excellent. Okay, we will be speaking soon. And so that's all I have. So
Very good.
thank you very much.
All right, guys.
Thank you.
Any further suggestions or comments?
Nope.
All right, then that concludes our meeting, you guys. All right, when's our next meeting? Are we gonna meet next
September.
month? Okay.
Yeah, I don't have the date right in front of me. September,
Third Thursday or something?
about a month from now.
Okay, good. You guys be safe. Talk to you
Okay.
later.
Bye.
Bye.
Bye,
Thank you.
everyone.
Oh, good
Bye,
night.
everybody.
Bye.